The employment tribunal has to be seen to be absolutely independent as part of the country's judicial system. They can't give individual claimants legal advice about their cases, and they are open to the public. You must make a written grievance to your employer before proceeding to the tribunal, even if your employment has come to an end. And you must then give your employer or ex-employer 28 days to respond to that grievance before you put in your claim. Now, if you fail to do that, the tribunal may turn away your claim at the outset. The proving of discrimination can be extremely difficult because, in my experience, very little discrimination at work, whether it's on grounds of race or gender or sexuality, is out in the open. Unless, of course, there's been some particularly nasty form of harassment. You may well be in a situation where you feel, for example, that you've been passed over for promotion because of your sexuality. But how do you prove this? One way to get information that may help your case, or at least clarify the issues, is to send your employer a sexual orientation questionnaire. The deadline for bringing any sort of discrimination grievance is 3 months, or less 1 day, from the date the discrimination occurred. So you must bear that in mind. If, as I've been talking about, you've lodged a written grievance with your employer, then that may extend the deadline. But you really must be very careful about not missing the boat altogether. So if you're in any doubt at all about whether you have a possible legal claim or not, and what the deadline will be, then you really need to seek advice, legal advice, at an early stage, sooner rather than later. You have to lodge the claim by completing a form called an ET1. This can be obtained from the Employment Tribunal service itself, or you can complete it online and submit it that way. Now, the form is not particularly complicated or difficult to understand, and you don't necessarily need to get legal advice to fill it in. It doesn't need to be written in legal language, for example. But whether you get legal advice or not, you should think very, very carefully about what you put on that form, because you are setting out the whole of your claim there. You may be able to get free advice, for example, from a law centre who specialises in employment and discrimination. You may also be able to get some free advice and help in preparing your case from a solicitor who has a contract to provide legal help under the government scheme. But bear in mind, that's only available to people on a low income. Other solicitors do, of course, prepare cases for the tribunal, but if you don't qualify for the legal help scheme, then you're going to be charged at an hourly rate, and that can get expensive. Now, if you don't have any of those options open to you, you shouldn't be afraid of representing yourself at the tribunal, because tribunals are relatively informal and they're used to unrepresented claimants, and they will be sympathetic and helpful. You will need to prepare your case by, for example, preparing a written witness statement and written witness statements for anybody who's going to come to the tribunal and support your case. You'll also need to agree a bundle of relevant documents with your opponent. One thing you should do if you can't get legal help free or can't afford to pay for it is to check any insurance policies that you have, like household insurance, because you may well find that you are covered for some legal expenses.
The way that employment tribunals operate is that all the hearings are before a panel made up of 3 members. The chairman or chairwoman of the panel is a qualified lawyer who is very experienced in employment law. They will also sit with what are called 2 wing members, who are usually not legally qualified, but they will have lots of experience in industrial relations generally.
If you win your case at the tribunal, you will be awarded any direct financial losses arising from the discrimination. For example, if you've been dismissed because of your sexual orientation, you can claim your net loss of earnings. You can also claim a sum for injury to feelings. That is to reflect the hurt or humiliation or embarrassment that has been caused by your employer's action.
Well, if the claimant loses their case and they are unhappy with the tribunal decision, then there's really two forms of appeal, if one can call it that. The first is they can have the decision reviewed by the same tribunal if it's in the interest of justice to do so, for example, or secondly, they can appeal to the Employment Appeal Tribunal, but they can only do so on a point of law. And should they wish to follow the second procedure, then really they should take some legal advice before doing so.
Whatever the outcome, going to an employment tribunal isn't an easy option. Make sure that you are well advised, supported, and have looked at all the options before going down this path.
The 2003 legislation is suddenly making people aware of their responsibility, both individually as managers and organisationally, to their employees.
I think it's important to recognise the tremendous advantage that the legislation has been to the LGBT communities. It has given us, as lesbians and gay men, bisexual and transgendered people, more confidence in challenging unfair treatment towards us.
Apart from the fact that it sets out a basic principle of human rights, I think it forces companies and corporations to police the behaviour of their own personnel.
What I think it does do is address some of the hidden things that we all forget about, like pensions, inheritance, etc., and how the company will behave over things like benefits.
One of the really big things in the 2003 legislation says that harassment is being in a place where your dignity is at risk, where you're being harassed, where you're feeling unsafe.
For the first time in history, lesbian and gay employees now have recourse to the law, and there's now a legal framework in which they can address the issue of discrimination.
It is getting better, and I think the pace of change has surprised a lot of people, and I imagine that the pace of change will continue to be just as fast for quite some time.
It is now illegal to discriminate against or harass anyone in the workplace on the grounds of their sexuality. We need to know our rights under the law and how to use them. If we experience discrimination or harassment, and if attempts to resolve discrimination issues fail, we can now take legal action. Thanks to the law, discrimination can no longer be ignored, and workplace culture is changing to catch up. By knowing our rights, we can all do our bit to stop discrimination and educate all those who are resistant to positive change. Many of the people who helped to make this DVD live and work in Southwark, and it has been shot mostly on location here in Southwark. However, I feel that the experiences portrayed will resonate with gay people in England, Scotland and Wales.
I have been involved with this project from the start and I'm very excited about it. It is a Southwark initiative where it started off from. It will be relevant to the whole country and I hope that people will use it and talk and it will stimulate conversation.